I hope you can all hear me. Thank you for joining us at our event, Putting a Will in Place During Coronavirus. My name is Anjum Khan, I am the director of the Asian Business Chamber of Commerce. So just to let you know today, so our presenter today is Rachael Armstrong, partner of VWV, and she will be covering why update your will, choosing the right solicitor, giving instructions remotely, and signing your will. We will have you will have a chance to do a Q&A at the end, and we're hoping to allow 20 minutes to that. So now I'll introduce you to Rachael.
Hi everyone.
Over to you.
Thank you. Okay, so I just wanted to run through a few things that I've seen coming in with my clients and queries that we've had with everyone. There'll be questions to you can ask at the end, and hopefully I can answer them for you. If there's anything that you don't want to ask on here and you want to contact me, my details will be at the end as well. So this is going to be a very brief summary, so I apologise for running through it quite quickly. First of all, I would be grateful if you would be able to answer the question that should be in front of you now, just to ask who exactly has a will in place. So if you have a will or not, if you can tick that for me, please. Just so that I can focus on either the intestacy provisions or not. So if you've all answered that, I'll get the... Okay, so we have got 5 of you don't have a will in place and 4 of you do. So just then briefly, let me get out of this screen just to bring up. So the intestacy provisions are what will happen if you don't have a will in place if something happens to you. And I've set it out in stages, depending, because everyone's circumstances is very different. So for example, if you are married and you don't have any children, then if you pass away, everything will go to your spouse or your civil partner. If you are married and you do have children, your spouse will get the first £270,000 worth of your estate, and half of the remainder will also go to them. The other half then would go to your children, and all the personal possessions will also go to your spouse. Now, this will have a massive implication if you have children from a previous marriage. You also need to think about the way assets are held. So, for example, a house can sometimes be held as what's called joint tenants, which means that wouldn't actually be part of the 270,000. So they may end up getting the house as well as the 270,000. On the other hand, it may well be that the house is actually worth maybe, for example, £600,000, and it's held as tenants in common, which means that you would own half a house each. So that half of the house would more than take up the 270,000, which was supposed to go to the spouse, and then they would get half of the remainder. So there's no guarantees without sitting down and looking at your assets in detail to be able to say what would happen in your own personal circumstances. Things like joint accounts, for example, would pass automatically to the survivor. So if you've got a joint account with your civil partner or your wife, then they would pass automatically and again would not form part of that 270,000. If you're then not married with children, then it would get divided equally between the children. So again, you have to be careful that if you're living with a partner, maybe you've children from a previous relationship, or you're living with a partner and you've got children with that partner, you have to be very aware that the partner may not get anything from your estate. They would then have to make a contentious claim against your estate to be able to get something, to be able to maybe maintain their way of life that they had with you. And that all becomes very messy, very expensive, and it goes to litigation instead of us dealing with it as per what your wishes were. If, for example, though, not married and there's no children at all, then it goes in an order of priority. And this can be, for example, so if it'll all go to surviving parents, first of all. So if you're living with a partner, no children, and you don't have a will in place, all of your assets would go to your parents. And again, this can be difficult if you have got a parent that you don't speak to, and because it will be your biological parents, unless of course you've been adopted. And if you've been adopted, then it's your adopted parents it would go to, because they become your legal parents. If both of your parents have passed away, then it would go equally between your brothers and sisters of the whole blood, or their surviving issue. So the whole blood basically means that you share the same mother and father. And surviving issue, so if one of your brothers or sisters had passed away and they have children, I use the word issue because that's the legal term rather than just children. An issue would be children, grandchildren, great-grandchildren, because it will pass down that bloodline. So if you, for example, had 3 siblings, one of them had passed away, but they had 2 children of their own, their 1/3 share of your estate would pass down to their children. If that sibling had died before you and didn't have any children, it would go to the surviving siblings. If there's no siblings of the whole blood and they have no surviving issue, then it would pass to brothers and sisters of the half blood. So that's where you share one parent. So it may well be that you have shared the same father or you have shared the same mother. You again need to just be careful about that, because a lot of people don't class their whole brothers and sisters different to their half brothers and sisters. And if you don't want to have that difference, you do need to make sure you have a will in place that talks about this. Or if you've got a sibling that you really don't get on with and you wouldn't want it to go to, again, you need to make sure you've got a will in place that leaves them out of it. If there's no brothers or sisters of either the whole blood or half blood or surviving issue, then it would go to surviving grandparents. The likelihood is that grandparents possibly have passed away at this stage as well, but it's just to be aware that's the next stage. And if there's no surviving grandparents, it then goes down to aunts and uncles of the whole blood. So again, that would be your mum and dad's brothers and sisters that they shared the same mum and dad, or their surviving issue. So that goes down then to nieces and nephews and their children. If there's absolutely no aunts or uncles of the whole blood, it then goes to aunts and uncles of the half blood. So again, where your aunt or uncle shared a mother or a father with your mum or dad. And if they have already passed away, again, goes down to the surviving issue. Now, you might think that this isn't completely impossible. It never happens. Believe me, it does. And we have massive family trees that we have to commission and put in place where there's no wills in place, and sometimes where it's maybe no children, no brothers and sisters, and we have to go back through the bloodline to see if there's anybody at all that can inherit. And we then end up contacting people through Finders and Fraser and Fraser, and you see all the genealogy programs on TV, and that's us that we're having to contact them to tell them actually your long lost cousin 3 times removed has actually died and left you now something in their estate because they hadn't a will in place. If there's absolutely no family, it then goes to the Crown. So it does go back to the Crown, so they would get whatever's in your estate. And again, I have seen that happen as well. So if you don't have a will in place, it is sometimes really good to just sit down and talk about it and see where you would want it to go to, what your moral obligations are, and so that we can make sure that we have talked it through and that it's definitely going where you would want it to go, whether that be charity, friends, or family that wouldn't be in the order that I've just said there. So that's intestacy rules, and that does take up quite a bit of time, but it's for the 5 of you that said you don't have wills in place, it's just making sure that you understand where your estate is going to go to, because everybody comes to me and says, when I was talking to so-and-so, I've been told this. Take legal advice on it, because what you hear down the pub is not always actually the correct circumstance for you. So why update your will? So if you've already got a will in place, it is always good to review it, especially at these times. And we're getting a lot of people coming in saying, I've been looking at this and I just want to double check. We recommend that you review your will every 3 to 5 years, just to make sure that the law hasn't changed, circumstances haven't changed. So some of the main reasons that we would look about why you need to review your will would be, first of all, your executors. So are they still the right person for the job? Maybe they've had sickness, ill health. Maybe they're a lot older than you. Maybe they've passed away. maybe you don't get on with them anymore and you used to be friends at the time, but they absolutely have no idea about your life, or you just don't trust them anymore, or you've got somebody else that you'd rather for the job. It may well be that they were on there when you had young children, and actually your children are now over the age of 18 and you trust them, you get on really well with your children, and you'd rather your children on there as executors to keep it within the family. So we would talk you through the options and who's best to put on there and things that you need to take into consideration. You also have to decide if your executors are the right people to be appointed as trustees. So normally your executors and trustees are one and the same people. So that executor, the difference is the executor deals with the administration of your estate. So they're the ones that are going to cash in your assets and then divide your assets out as per what you've asked them to do in the will. Trustees are going to be the people that if you have a trust in place, so for example, you're giving it to your children on, at the age of 25, so it's going to be held in a trust until that child reaches the age of 25. Now you can give your trustees the authority to pay it out to the children earlier, and that 25 is the legal age that they can come and insist upon it. But if they came at 21 and they wanted to maybe buy a house and they wanted a deposit for the property, you could authorise your trustees to say, look, I would like you to give it to the children at 21 if they're sensible and they would like to buy a house. You could put extra guidance in there as well, that we normally put in an attached letter of wishes for the trustees to say, however, if they're buying the house with a partner or somebody else, that you would like them to make sure that a declaration of trust is put in place to protect the deposit monies that they are putting in, because it might well be that they're putting in a substantial amount more than what the other person is. And also for them to maybe check, is it a good buy, or is it really not a good property and they're just being frivolous with the money? So it's again about giving your trustees that authority. We always say with your trustees, you need somebody who is strict enough that they're not just going to be pressurized by the beneficiaries. You need somebody who is not too strict, that's just going to sit and hold on to the money and not consider any requests that have come in from the beneficiaries. And you need people that get on and trust each other, because there's no point in having a trustee from each side of the family if you are a husband and wife or partners and they don't like each other. And because if they don't like each other, you're going to end up just not getting anywhere with the trust, because they have to agree unanimously on all decisions that they're making. The beneficiaries then, you have to double check, have these changed? So have any of these passed away? And if they've passed away, have you allowed for that gift to pass on to their children? Would you want it to pass on to their children, or do you really not get on with the beneficiary's children? So you just need to maybe double check that it's still going to the people you'd want it to go to. If you've got any moral obligations to anyone who's not been included in your will. So since the time of making your will, maybe you've started living with somebody, and if you've lived with somebody for over 2 years, then they have a right to make a claim against your estate if they've not been included in it. So you need to check, well, what are your moral obligations? Who do you need to be thinking about? And it's better to have thought about it before you die, because the animosity after your death and trying to get the beneficiaries then to agree and negotiate, there's a lot of money that gets spent on the litigation and the contentious side of trying to get an agreement between everybody. Equalising gifts, we get this all the time, where we may have that you've lent money or given money to one of the children and your estate divides it equally between, say, for example, use the 3 children again. So your estate divides everything between the 3 children, but one of those children has already had maybe £100,000 or £50,000 or whatever it is that you've given them. And it's about, well, if something happened to you, are you happy that they get to keep the money they've already had, and they also get a third of the rest of the estate? So sometimes we have to sit down and talk about how we equalise that, and are we going to make sure that the other children get that figure first before it's equalised, or are you happy that that is extra, that they look after you and that's what you would want them to have? So there's different ways that plans that we can put in place for that, but it's something to take into consideration. Also, it may well be that you've lent money to the beneficiary if you've lent it and you're expecting that money back, that's part of your estate for calculating inheritance tax. So although you might never expect it back from them, if you're saying that's a loan, then that would be taken into consideration when working out the value of your estate and then what inheritance tax is paid. If, however, you've gifted it straight to that child, then you've to survive that gift by 7 years, and then that's already out of your estate and does not get taken into consideration for calculating inheritance tax. And bearing in mind, inheritance tax is charged at 40%. Over there's certain reliefs that are available. So again, it's about sitting down and looking at what's the value of your estate. Do you need to forgive the loan? Is it better for you to forgive it so that we try and get it out of your estate? And this is where we sit down with you to go through everything that's in your estate. The beneficiaries continue. So does the beneficiary need or want the gift? So we get a lot of families coming in where actually they're giving it to their children. Their children are already taxable in their own right and they've got their own money and they don't want it. They don't want to receive it. They'd actually rather it went straight to their children. And it's about making sure that there's that open line of communication, that you've talked to your children. And if they don't want it, then update your will to give it straight down to the grandchildren instead. Or if there's a vulnerable beneficiary. So again, it's about having those conversations. Do you have a child or a grandchild or one of these beneficiaries that you're giving it to in receipt of benefits, means tested benefits, because they're autistic or that they've got some form of vulnerability that the government recognises and that they do qualify for benefits? The most of the time, the benefits that they qualify are means tested. And if you are giving them, this beneficiary, a large amount of money, you are going to probably ensure that they lose their benefits. And not only do they lose their benefits with the cash sum, they then lose the connected benefits. So things like maybe a disabled pass possibly, or a cinema tickets, or carers. So you just need to look into that a bit more. And if you do have a beneficiary like that, and we do find that's happening more and more and more these days, that we would advise maybe putting it into some form of trust for that beneficiary so that it's not actually theirs, but it's there, it's available to them if they needed it. And there are other types of vulnerable beneficiaries that you might want to consider as well. So if you have a child that's going through a divorce, or one of your beneficiaries is going through a divorce, or they've been made bankrupt, again, you wouldn't necessarily want the money to go to them directly, because it would just get wasted in either the divorce settlement or have to go to the trustee in bankruptcy. There's other different types of vulnerable beneficiaries, but again, this is the type of meeting that we would have with you to just discuss what your own personal circumstances are. It's also good to review the tax implications. So is the will actually tax efficient? So with the new reliefs that came in 3 tax years ago, well, this is the 4th tax year now, with the residential nil rate band, are you able to apply for them? Is the way the will is worded and set up, does it allow you to apply for them, or does it make sure that they're actually not available to you? So it's about making sure that your will is drafted in a way that is protecting you, but is also giving you the best access to the tax reliefs that are available on your death. We also get a lot of couples that have life interest trusts in place. And this would be, for example, where you own a property together and you are gifting your half share to your partner to continue living there. This is okay if you're married. And again, it's fine to do it otherwise, even if you're not married. But if you're married, you get the tax reliefs of being a spouse exemption. If you're not married, it's classed as a gift and it comes out of the reliefs that are available to you. So normally I sit down with my clients and do a tax calculation to show the difference in if you're married and doing a life interest trust, and if you're not married and doing a life interest trust. And it can be quite scary, the amount of tax that you are going to pay because of having a life interest trust in place. And you've got to check, is that the right thing for you? So we've had some clients recently that had these in place to try and mitigate against nursing home fees. But when we sat down and we questioned them in detail, they actually wanted to make sure they'd no children. They were giving it to a niece, and the niece had enough money anyway, and they wanted to make sure each other was looked after. So it was the wrong type of will for them. So then if we move on to the change in circumstances, so the divorce and marriage, I talked about that. So again, it might well be that you have put a will in place and you've since got divorced, and it's about making sure again is the will worded in a way that you're protecting the money against going to your divorced husband or wife? So, for example, if you're giving everything to your child and you're not putting an age contingency on that to go to the child, if that child then dies after you, so say you're in the same accident and they die, maybe a year later, or whatever happens to them, and they haven't put a will in place, that will then end up going back to your spouse. So you need to make sure that you're comfortable, or your ex-spouse, you need to make sure you're comfortable with that. If you have put a will in place and you've got married in the meantime, that will revoke your will. So a lot of people don't realize that getting married actually makes your will null and void, and you do need to put a new will in place. So again, it's about making sure that you've either put the right clauses in place before you were getting married and you put the will in place, or that you've done a new will since then, and we've discussed where exactly everything is going to. So again, it's about choosing the right solicitor. You do need somebody who's not just going to take a list of instructions from you and put it all into a will. That's not giving you the best advice. That's basically you saying, here's my shopping list, can you put it all in there? Whenever I'm sitting down with a client, the structure of my meetings so that we go through the finances, we go through the family situation, and we go through the background. And only whenever I've gone through all of those three areas, I can advise you if what you're giving me is going to be helpful for you, if there's another more tax efficient way of dealing with it, if there's something else that you need to take into consideration. So it's about making sure that I have given you a bespoke service that's just for you. The Society of Trust and Estate Practitioners is what I'm part of as well. It's an extra diploma that we do to qualify. If you're going to a solicitor, I'd always recommend that you go to a step practitioner. And that, as I said, they're not just taking your structure, they are going through all of those three elements that I've put on there and giving you the chance to ask questions. A step solicitor should also be able to go through things like your foreign assets and advise you on the pros and cons of what you've got in place, so all are things that you need to take into consideration. And again, we also need to talk about domicile, and that's what we would do in each meeting. So, for example, with me being Irish, I am classed as domiciled in Ireland. So my spouse would not get the 100% spouse relief that would normally be available to a UK citizen. So it's about, again, looking at your individual circumstances. Are both of you domiciled in the UK? If one of you is domiciled in the UK, how does that fit into your own circumstances? And that can have a massive effect on the tax implications as well. I'm sorry for rushing through all this. It's just there's quite a bit to get through. The slides are all obviously going to be available, and as I said, you can ask me questions. So choosing the right solicitor, you've got to. We would be talking about the tax implications of what you've put in place. Like I talked about the trusts. Is this the right thing? If it isn't, if you want more control and maybe lose a bit of the tax reliefs that are on there, again, it's so that we've given you the options that are available and you make an informed choice rather than you just giving a list of things that you would like in there and nobody's actually explained what the tax consequences of those are. Again, we'd look at even if there's any family businesses and how they would pass on your death, and again your moral obligations. So if you've since got married, if you're living with somebody, if you've got children who are vulnerable, etc. And this is what I would ask. So you'd be open and honest with us. You'd be open-minded with the advice that we've given. You have to be decisive then with what you're wanting us to put in place for you, and you keep in contact and review it periodically, so every 3 to 5 years. So in this time, with the coronavirus, it's very difficult. With obviously being able to sign wills and getting in to see solicitors, and we're classed as key workers, so we are able to actually go out and visit you if we need to. I've had a couple of clients that I've had to go out and we've had to see them. A lot of the calls that we're doing though, we're doing via video call. Getting the identification, we've worked with our compliance team to see what we can accept and how we do it, and we have worked through that, and provided we can get photos from smartphones, we can use that instead of getting the ID, the hard copies of the ID. And video calls are a great way forward, and a lot of people said to me, oh, they would never do it, but actually the clients that I've spoken to really appreciate it, and being able to see someone's face and be able to talk to someone so I can see if they're confused or if they need me to go over something a bit more. And then email, we're actually emailing the wills out at the minute. Clients, if they have the printer, they can then print them on themselves, and then we're talking about how they then need to sign them. So signing your will, the legal obligations that you have to do is that you have to have 2 witnesses. The both have to be present at the same time whenever you're signing. And the will needs to be dated. Now, with the witnessing, everybody has to be present at the same time, and you all have to see each other sign. It's not good enough to take it to one person and then go to the next person's house and get it signed there as well. That would make it invalid. And believe me, we see that all the time. So it's very important that you speak to your solicitor and you're making sure that it is absolutely signed correctly, because there's no point in going to that expense and doing everything that you need to do and it not being signed correctly. But signing correctly is also now needs to be done with making sure that you've complied with the social distancing. I'm going to come back to this page, but with the social distancing, we're saying that you need to meet in an open space, so whether that be in the front yard or a garage underneath flats or in the garden, bring a chair out or use the car bonnet. We're telling everybody to wear gloves so that it's not passed on the paper. You bring your own pen, so whoever you're asking to come and sign this with you, you ask them to bring the pen with them and wear gloves, and that they are going to be witnessing your will. And then with the storage afterwards, that once it has been signed, that you put it into an A4 envelope immediately, because they are saying that the coronavirus can last on paper for, depending who you speak to, whatever, 12 hours, 24 hours, 2 days. So put it into the envelope and then give it to your solicitor for storage. We're asking people just to scan it in if they can, or take photos of it, just so that we can make sure that it has been signed correctly. Going back to the previous page, other recommendations. Binding the will, we're asking, if we're sending it out to you by email, that you staple the top left-hand corner. You do not attach anything to your original will. You do not remove that staple as soon as you have put it in there, because the court will ask questions about why that has been removed. If there's any indentations for a paper clip or anything like that that has been attached to the will, again, the court will ask questions about that. So you're better not to attach absolutely anything to the will itself. We also recommend signing each page, because then that way the court can't ask, well, were all the pages in front of the testator whenever they were signing it? And then, sorry. So that's just a bit about our stuff there. And then it's so just asking if there's any questions that you have. So there's a couple of questions that have come through. So should a discretionary will trust for 325,000 be used on first death of wife or rolled over to husband on his death? Also, will the residence nil rate band automatically be rolled over if not in wife's will, or should a deed of variation be done? So there's a lot of questions. It depends on the individual circumstances. So again, a lot of discretionary trust wills were set up prior to 2007 when the law changed. It's not the wrong thing to have them in place, and we sit down with our clients to look at what's the value of the assets on the deceased's death and what are the value of the assets then on the surviving spouse's death. So we need to look at, well, is the surviving spouse going to be over 2 million? And if they are going to be over 2 million, we need to then make sure that we're trying to bring their estate down. And the reason we're trying to bring their estate down is to make sure that they can get the residence nil rate band. So the residence nil rate band came in on the July 2015, and this is the 4th tax year now, and it's currently worth 175,000 per person. So if you're a married couple and you're giving everything to each other, then the children, essentially you have £1 million before you have to pay inheritance tax. So we would, if you are over 2 million, though, you lose £1. Sorry, for every £2 you're over £2 million, you lose £1 of the residence nil rate band relief. So you only have to be in a state of 2.7 million and you've completely lost your residence nil rate band relief. So again, it's looking at your individual circumstances. It's not a bad thing to have it in there, but it's about us looking at it and saying, well, is that the right thing to still be in there? It will automatically roll over if it hasn't been used, but again, it depends on if the house has ever been in the spouse's name. So the house has to have been in the spouse's name as their home, and they've had to own it legally. So if, for example, that spouse is in a care home and then it goes into their name, then they've never actually owned it as their residence. So there are issues that we have in respect to that. But it's a good question to ask, but it's more that it's a very specific question that we'd need to look at with your individual circumstances. Is it worth putting a will in place if your only asset is a house? Yes. Again, it depends on your circumstances, if it's a spouse, if you own it as joint tenants. It is always good practice to put a will in place as well. I've had a case where a client didn't put a will in place, died intestate, thought he was simple, straightforward, it was just passed to his siblings. The problem was is that a child came out of the blue that he didn't know anything about, and after a DNA test, it was discovered that she was actually his child and she was the one who was entitled to it, even though he had absolutely no relationship with her. So it's ended up in a contentious case. So it is always safer to have a will in place because you know that it's going to go where you want it to go to.
Thank you, Rachel. I do have a question as well that's come through. Somebody's asking, if they've already got a will, do they still need a power of attorney?
Power of attorney, they're very different. Power of attorney deals with your assets during your lifetime. On your death, the power of attorney ceases, so it can no longer be used. Your will deals with everything then after your death. So basically, if you think of the power of attorney goes up to one stage, up to death, and then after your death, the will deals with everything. So it is good practice, again, to always have that will in place.
Thank you. And one more question then. What is the difference between a living trust versus a will?
So a trust that's put in place during lifetime and a trust that's put in place in the will. So the trusts take on many different forms. It really does depend. A living trust basically is set up in your lifetime, so it's something that you have set up. Now, you cannot benefit from a trust that you set up in your lifetime. It has to go to somebody else. So it may well be that you set up a trust to benefit children in the future, or that you want to give a life interest, etc. There's a load of different reasons that you would put it in place. One set up in your will is one that you basically have transferred your assets on death into. In your will, you can put as much into the trust as you want, and there's no tax for it going into the trust. And again, it depends on the type of trust and who it's going to, the taxes we're talking about. So this is very loosely explained, so I apologize. But on your lifetime, you're allowed to put in 325,000 without paying what's called a lifetime chargeable transfer fee of 20%. So it is about, again, sitting down with your advisor, what it is you're trying to achieve, and then what we have to take into consideration things like gifts that you have already made, because they will come off that 325,000. We've got to think about what assets you're putting in there, or the reliefs available in respect of that. So it really does depend on if you're, and we've got clients that do both. They set up ones during their lifetime and they set up ones on death as well.
Sure. Okay. Thank you, Rachel, for your time today. And if anyone's got any questions around a will, as there's loads to look into as well, please, on your screens, you will see Rachel's contact details. But by all means, if anyone's got any other further questions, you are able to contact me. Just so you know, on your screen also is our website where we've got all information around coronavirus, and my email address as well. And our next webinar is taking place on 23rd of April. It is about, is your business digitally fit? So please do book on if that's an interest to you. Rachel, thank you so much. It's amazing how much you've gone through in just over 20 minutes.
A lot of information.
Absolutely. So I'm just going to put Rachel's details back on to say, please note her email address or contact us at the chamber, and we'd be more than happy to pass on any queries that you do have. Thank you. Thank you, everyone, and please do stay safe. Thank you, Rachel.
Thank you.
Bye-bye.